5 seconds to go. Start. On an examination of the pleadings of two writ petitions, we find that the issues for consideration were all different in the petitions. In the first petition, relief was sought under the Contract Labour Act 1970 for abolition of contract labour system in the operation of canteen in the marketing establishment of IOC and for absorbing the canteen workers as employees of IOC. In the second petition, relief was sought under the Industrial Disputes Act 1947 for making a reference under section 10(1) to the Industrial Tribunal to decide whether the contract between IOC and the canteen contractor was sham, nominal, and a mere camouflage to avoid extension of labor law benefits to the workers in question, and whether the canteen workers were the direct employees of IOC. The assumption that the appellant had taken inconsistent stands in the two writ petitions is not correct. Even in the first writ petition, the appellant had contended that though the contractors changed from time to time, the workers in the canteen remained the same with continuity of service, that IOC had mala fide and illegally kept the workers as contract labor in order to keep them in a permanent state of insecurity and to deny them the wages and privileges available to permanent workers, that IOC was actually controlling and supervising the canteen, and that only as a camouflage the contractor was shown as running the canteen to create a pretense that the workmen of IOC were the workers of the contractor, when in fact they were the employees of IOC. In short, the respondent had contended that the contract was sham and nominal in the first petition. Even in the second writ petition, the contention was that the contract was sham and a camouflage to avoid extending benefits of regular employees to the canteen workers. Therefore, the High Court committed a serious error in assuming that in the first writ petition the appellant had conceded that the contract between the IOC and the canteen contractor was valid and genuine, and that in the second writ petition the appellant had taken a contrary stand, that the contract was sham and a camouflage. The stand of the appellant and the workers was always consistent, but before the decision of a constitution bench of this court in Steel Authority of India Limited versus National Union Waterfront Workers 2001-7 SCC 1, it was thought that the appropriate relief available was to seek an investigation and abolition of contract labor and consequently seek absorption. Therefore, the prayer was made in the first petition. This court held that even if there was an order under Section 10 of the Act prohibiting contract labor in any process or operation, there would be no automatic absorption of the contract labor by the principal employer. It was also held that it is always open to the contract labor to urge that the contract was sham and nominal by raising an industrial dispute, and such dispute will have to be decided by the industrial adjudicator and not by the High Court. Stop.